Thanks for joining.
Okay, so hello to everyone and welcome to the distinguished speakers that we will have today. My name is Angela Tacha. I'm an associate professor in Sciences Po Grenoble. And this webinar is actually part of the effort Sciences Po is putting in professionalizing students. So Kevin, Alicia, and Oguzhan are organizing this webinar. They have been working for more than a month to organize it, and they organized it from the beginning, and they will organize it until the end. And let me welcome you all, and I hope you will have a fruitful and productive session. And I give the floor to Alicia for introducing the topic.
Hello, everybody. Thank you very much, Dr. Tacha, for introducing us. Thank you to our audience for joining us today from wherever you are coming from. So as mentioned, we're arranging this webinar as part of our studies. Myself and Kevin are here in Grenoble on exchange as part of an international master's in European politics. So myself, I'm coming from the University of Bath in the UK. So hello to those of us joining us from Bath. And Kevin is coming from the University of North Carolina at Chapel Hill. Welcome to those of you joining us from across the pond early in the morning. And Oguzhan also studying here on the European Governance course from Turkey. So welcome to anyone joining us from Turkey. So to briefly introduce our topic, so we're broadly focusing on the intersection of migratory politics and the rule of law in the EU. So in the area of EU migration, member states have varied in their responses to the challenge, and this has raised concerns about humanitarian values versus political interests. Some member states have invoked emergency powers, challenging the existing rule of law. This webinar will explore these challenges, impact on European democratic values, and the rule of law legitimacy. So why we came to choose this topic, our interest in this topic stems from two directions. Firstly, our interest in democracy and interest in migration. So in 2024, more people will vote in elections than have ever voted in human history, with elections including EU elections, US elections, UK general elections, and Russian elections. However, out of scheduled 76 elections, only 43 have been judged to be free and fair, according to NBC researchers. Therefore, we felt it important to highlight the fundamentality of democratic values and the rule of law. Moreover, our interest in migration becomes increasingly more salient as time goes on. With the new pact on migration being agreed in December last year, we expect there to be a continued emphasis on migratory issues in EU politics and continued difficulties in managing this. So to welcome our speakers, joining us today on our panel of excellence, we have Gaia Romeo joining us from Brussels. Ms. Romeo is a PhD researcher of political science at the Centre for Migration, Diversity and Justice at the Brussels School of Governance at Vrije Universiteit Brussels. Ms. Romeo's research currently focuses on the implementation of EU safe third country policies in relation to human rights. Our second panelist is Professor Elspeth Guild, joining us from London. Professor Guild is a professor of law and Jean Monnet ad personam at Queen Mary University of London, as well as the Radboud University Nijmegen in the Netherlands, and also a visiting professor at the College of Europe in Bruges. Professor Guild's work specialises in the area of EU law, in particular EU justice and home affairs, such as security, immigration, asylum, and border controls. And finally, we have Mr. Luca Perilli joining us from Verona. Mr. Perilli is judge and chair of the specialised section for the international protection of the Trento court in Italy. Mr. Perilli's work specialises in civil justice, including migration and human rights law, as well as the effectiveness of justice systems. Mr. Perilli has worked on numerous projects with the European Commission and DG Enlargement as EU independent expert for the accession of candidates and potential candidates to the EU. So just a final note of housekeeping. Our structure of our webinar, to start us off, our lovely guests have prepared some introductory statements pertaining to our topic. Then we'll proceed on to a more open discussion. And we shall end our webinar with a Q&A session. And how we will work that is any audience member that has a question, you're invited to put your questions in the Q&A function on under the little more section. So just pop them in there as we go, and we'll compile them as the meeting goes on, and we'll pose them to the panel when it's the appropriate time. Finally, if there are any technical glitches, do bear with us. We were meant to be hosting this webinar from the Sciences Po Grenoble campus. However, in typical French tradition, there are strikes and protests. So we have been blocked entry to the building, so we can't get in. So we're coming to you from our bedrooms, essentially. So yes, that's the final note for housekeeping. I shall now hand over to our speakers to kick us off. Would anybody like to volunteer to go first?
Alicia, why don't you take us in the order in which you've introduced us?
Okay, that works perfectly fine. Okie dokie. How about Ms. Romeo? Would you like to start us off?
Thanks. Well, thank you very much, Alicia, for the great welcoming. You're a really talented webinar presenter. So thanks a lot. Yeah, so you send me a lot of inputs and you're killing me with your 5 minutes time limit. As academics, we like to speak a lot. Okay, there are 3, maybe more points that I would like to share to start this discussion. The first point is about, migration and crisis. In the last decade, we have been hearing a lot about migration crisis. But is there really a crisis, or are there make-up crises? Well, of course, there are years where we have a higher inflows of refugees and years than we have less. But then if we compare, for example, 2015, where we had 1.3 million refugees coming from the EU, and 2022, when we had 6 million refugees coming from Ukraine, we see that the narratives around these refugee crises were completely different. In 2015, we had what was defined as a crisis, and it was indeed a crisis, but because it showed that there was actually a crisis in the EU approach to migration. While in 2022, in relation to 6 million Ukrainian refugees coming from the EU, a narrative of empathy, solidarity prevailed. And the response from the EU was also very different. It was very swift. The EU agreed very quickly in activating the temporary protection directive, and we didn't perceive it as a migration crisis. So, of course, you can have, let's say, different contexts, but it's really important how what's the narration around it. And it also has an impact in the response that is given to this crisis. All right, then about this link between securitization of migration policies, border procedures, emergency powers, emergency measures. After 9/11, we have assisted to a clear shift of migration policies towards a securitization narrative with this emergency, yes, of very emergency measures to deal with the refugees inflows. I am not a lawyer, I'm a political scientist, so I cannot speak about the more technical impacts of all of these on the rule of law. But as someone who studied implementation, I can see from that perspective, I can observe something from that perspective. And it is the following, that we see that there are a lot of new policies that are launched at a EU level, but also at a national level. The EU-Turkey statement of 2016 between the EU and Turkey, but also Italian's policies such as the Memorandum of Understanding with Libya or the new plan with Albania, or if we go out of the EU, the UK plan with Rwanda. And these policies, they are adopted on a very, let's say, emergential note, but it's not really clear how they will play when they are operating in the context. And that creates a lot of different problems. One is a very practical problem, meaning that when these policies are adopted, there's not a very thorough assessment on what's really going on the ground and how they can be really implemented in a very practical way, how they respond to the very practical needs that you find on the fields. And then there's also a problem of the normative context in which they are playing. It's not really clear if they can be implemented in the context of the national and international legislation. The consequence of all that
are two. One, that there is a dynamic with tribunals. So the policy is taken, is launched, it's operating, but then there is this testing dynamic. So some parts of these policies are challenged before tribunals, and tribunals set a bit which part of the policies can be actually implemented and which cannot. But this dynamic is very complex. And the other consequence is that a lot of very informal practices emerge on the field for different reasons. Sometimes because these policies are they have a very political value. So let's say officially, EU and national institutions have to defend the policies, but then they know that they are not very effective, and they have to find ways actually to deal with the situation that they have on the field. So maybe they push street level implementers to use less restrictive policy to actually meet the needs that they have. And what does it mean in terms of rural law? That because none of this is written or is fixed, but informal practices change all the time, it's very difficult for lawyers that want to challenge these informal practices to actually do it, because they cannot prove that they really exist, because they are not official, because they change all the time. At the same time, let's say the good part of this informal policy, is that sometimes actors that are on the field use this informal policy to actually find a way to turn around the official policy, especially when it's harmful for human rights. So they cannot defy publicly the official policy that is very restrictive, is very harmful, but they find a way to turn around it to actually limit a bit the human rights violation. And I'm sure that I've already been talking too much, so I will stop here.
Thank you. No, those were some really interesting insights. No, that was amazing. Thank you. Who shall we have next? Can we have Professor Guild? Would you like to introduce us?
Yes, thank you. Thank you very much, Alicia, and also to Gaia for a very interesting introduction. I'm going to be very short. And what I want to do is to place our discussion in the factual context. And here I will suggest that we all look at Frontex's annual risk assessments. The final 10 pages of the risk assessments provide us with statistics about entry into the EU across the external border, refusal of entry at the external border, and expulsion, as well as a number of other topics. And from those statistics, which are the statistics that our border guards provide, given to the EU's border agency, there are over 3 million crossings of the external frontier of the EU every year. Now, that includes EU nationals as well as third country nationals. Of that 3 million, there are under 200,000 refusals of entry at the external border every year. Okay, so we're looking at about a 0.002% of persons crossing the border are refused entry. We have about 15 million visas applied for every year, and what the European Commission calls the non-issuance rate is about 13%. We then have the question about how many people do we expel from the EU every year, and this number has been dropping substantially every year since Brexit. The Brits really love expelling people, whereas other states don't. And it's now down to about 90,000 people a year. This is the number of people which the member states are willing to pick up by the scruff of the neck and send elsewhere. They dislike them so much, they want to get rid of them. Now, in the light of these statistics, is it comprehensible that we have spent hundreds of thousands of the most expensive time in the EU, of the European Parliament, the Council, and the Commission, designing a whole new pact on borders, migration, and asylum? And I would say this sounds highly disproportionate to me. This does not sound like a good use of EU money for what is obviously not a crisis in terms of the numbers of persons. Now, we can say, well, how many people applied for asylum? Well, it's about 600 to 700,000 people a year. when you're looking at an area of 450 million people, over 3 million entries every year, surely we're not looking at numbers which are those of crisis. Further, of those about 600,000 to 700,000 people a year who apply for asylum, more than half of them, usually about 50 to 60%, are granted some form of protection. So they needed to be here. Therefore, I think when we try and look at what is the context in which we are discussing migration, we need absolutely to go back and look at what is actually happening. What is the information we have about what is happening in respect of external borders, refusal of entry, and expulsion? And perhaps think that the same rules of proportionality, which apply to all other areas of the EU law, should apply here as well in respect of expenditure. Thank you very much.
Well, thank you very much, Professor Guild. No, that's a very interesting perspective. I think the concept of proportionality is definitely something that should be taken on further into the future. Thank you. And Mr. Perilli, would you like to finalize our introductions?
Thank you. Thank you very much for the invitation. And good afternoon to everyone, to the participant, to the speaker. So this principle of proportionality indicates as the situation should be, but the reality is a bit different. And I will focus on the topic of fundamental rights and rule of law, three concepts, starting from the first one, which stems from the use of the language and the words by the general people, by the media, and sometimes also by the politicians. So those asylum seekers, the professor said around 600,000, it varies from 400,000 in 2014, 1,200,000 in 15, and 20 last year, 2023, I think it almost 1 million. So there was a great increase, especially in the southern country. I mean, those are asylum seekers, but in the language, they are irregular people. They are sometimes clandestine. Sometimes they are illegal people. Clandestine implies something which is illicit. It is that in the reality, according to the law, our legislation, the Common European Asylum System, and the Charter of Fundamental Rights, which is triggered by the European law in this field, asylum seekers are strongholders of fundamental rights. I will mention some. The right to adequate reception conditions, the right to get full information about the asylum procedure, the right to be supported if they are in a situation of vulnerability. We can also discuss later what support means for a judge. The right to defense, a right to legal aid, a right to stay free without liberty restriction pending procedure, the right to access fair procedure, the right to an effective remedy by an independent judge, and finally, and first of all, the right to access the EU territory to be allowed to exercise all the above rights. And this is rule of law. Unfortunately, the tendency, and this is the second concept, and is already what Gaia said, is different. So the politics. The politics are in the direction of the externalization of the border, the externalization of the asylum claims, and the asylum seekers. And this is also visible in the new pact that has been mentioned and is under the scrutiny of the European Union Parliament these days. In simple, the idea is that migrants should be prevented from entering the territory of the European Union, or should be rapidly refueled according to border procedure, and they also use this concept of fiction of non-entry, if they are not entitled to international protection. And this is grounded on an assumption. The assumption is that their rights can be protected elsewhere, or at least they could stay elsewhere safely, because the main tool of the externalization is this concept of safe third country. But the political contradictions in this context emerge clearly and immediately. For example, the EU-Turkey agreement already mentioned by Gaia of March 2016 that was aimed at stopping the flow of irregular migrants to EU. If we look at the statistics, still in 2022, Turkey ranked in the 4th place for number of asylum seekers from Turkey in the European Union. And the trend was similar in the previous years. Or, for example, for Italy, further clear political contradiction is the inclusion in the list of the 3rd safe country of origin, among others. There is also the Cote d'Ivoire, the Guinea, but even the Nigeria. And for the Nigeria, there is the country guidance note of the European Union Asylum Agency, which is an agency of the European Union. Nigeria is classified as non-safe country, and it is in the safe country of origin list in Italy. And let's come to the last concept, emergency. What means emergency in the field of asylum? From my point of view, it means especially the implementation of border procedure as a consequence of the implementation of this fiction of non-entry and safe country concepts. And border procedure are more and more connected to significant cut of guarantees for migrants that are envisaged by the European asylum system and situation of detention, which is more and more common and also included in the new pact. And this situation goes at particular detriment of those asylum seekers who are vulnerable. Vulnerability is a legal concept, it's not a social concept. And it is protected, vulnerability, by the common European asylum system. And because they are entitled to special reception condition and special procedural guarantees. And according to my experience as a judge, I've dealt with hundreds and hundreds of cases in the last year. Those who cross the desert and the Mediterranean, but also those who go through the Balkanic route and come to our countries, among them, a large part is made by vulnerable people. These people should be exempted from the border procedure and should receive full support by the state. So the implementation of emergency rules will probably prevent even from the identification of the vulnerable people, which is the first step in order to guarantee support and protection. Therefore, what I see is not a conclusion, but that we are in front of a double standard in the implementation of fundamental rights in the EU when we are dealing with citizens, or on the other side, we are dealing with migrants. This is the risk in the context of on the rule of law. Thank you for your attention.
Well, thank you. Thank you very much, Mr. Perilli. No, those are some really interesting insights. I think also the concept of vulnerability, the sort of concept of emergency powers impeding the process of helping those vulnerable. No, that's definitely very pertinent to this wider issue. So question to anybody who would takes an interest. What do we think, sorry, I'm just looking at my questions. In what ways do you think these events might have affected the public's perception of the EU legitimacy and effectiveness at handling such crises and things that have been mentioned?
I can go first with a very short answer, just a few points. Well, we are seeing now, so we are at the end of the legislature in the parliament, and we know that most likely the new Pact on Migration and Asylum will be ratified in the next few months. And this has been portrayed as a victory by all, let's say, the centrist, more centrist groups in the parliament, the EPP, the Socialists and Democrats and stuff, and from the Spanish presidency and now the Belgian presidency. And the new pact is very disputed from, let's say, the more leftist and the more rightist group. But for all the more centrist group, it's portrayed as a victory. And it is, of course, because this fact that we have been we have been since 2015, 2014 in this state of crisis towards the management of migration and asylum. It is a big thing, of course, for the legitimacy of the institution. Like how can we be like a political union and not be able to find a solution to manage migration? Okay, we discuss how maybe the crisis is make up or it's a question of narrative, but it's still an issue. We have to find solutions. And while everyone is unhappy about the pact for different reasons, there was still like a big political push to adopt it by the end of the legislature, with this idea that something had to be done, because it's a very big political problem if nothing is done. It's a problem of legitimacy for the institution if no way is found. Then, of course, I would personally argue, I think that the new pact will create more problems than what it will actually solve, but that's something that we will see in the next years. We don't see it now. For now, what will be what the message that will pass is we made it, we found a new way to manage migration in the EU.
Thank you. Would anybody else have any comments on that?
Yes, I want to come in. After my great plea on proportionality, I would like to support enormously Luca and Gaia's position that the delivery of this horrendous degree of violence against an extremely small number of people is unacceptable and contrary to the fundamental rights which are set out in the Charter. I think that as Gaia has been saying and Luca has been referring to, the political agreement on the new pact, the provisions on migration went through about 2 months ago, and on blue card and single permit, etc., and are pretty, well, they're not good, but they're not terrible. What's dreadful is what's happened to the Common European Asylum System, where agreement was reached just before Christmas, and we've only just now got the texts out. And as Luca has been saying, the introduction of the non-entree fiction and the creation of this new border procedure, which will constitute a horrific denial of access to justice for asylum seekers in the EU, is utterly unjustified. It is, I think, the package which we've got now, as the European Council for Refugees and Exiles stated in their editorial last week, is that we all lost the debate. The far right managed to push the centre right in the European Parliament sufficiently far to put into law a series of measures which are obviously and clearly inconsistent with the Charter and with judgments of the Court of Justice already about the application of the Charter to the Common European Asylum System. So a great setback. In terms of politics, we know that as soon as the centre-right gives in to the far-right on migration and asylum, the far-right is never satisfied and always goes to an even further extreme. So there's no point trying to throw red meat to the extreme right, because they'll never be satisfied no matter what you do. Therefore, protecting and enforcing and implementing fundamental rights in the area of asylum is what ought to have been happening in respect of the European legislation on the Common European Asylum System. And this has been thrown in the rubbish bin by fears about how are people going to vote in Europe in the parliament elections in June, and how can we reach some kind of agreements with the extreme right parties in certain countries. And I think this is a terrible indictment of where the EU legislator is at the moment.
Thank you. Yes, no, the far-right sort of populist parties, that sort of concept definitely becoming increasingly more and more important on the sort of European stage, we see. Mr. Perilli, do you have any comments on any of that?
I would like to make a bit different comment, because I will not step into this discussion about right and left and political parties. Being an active judge, I refrain from speaking about parties and politics. However, I have some consideration in general about the direction of this new pact. My point is that in order to implement a pact that will contain restrictions to the rights of the asylum seeker, it will be of utmost importance to have mechanism in place that guarantee that the fundamental principle of the common European asylum system are respected. And as we said, since we are in the field of implementation of European Union law, the Charter of Fundamental Rights is always triggered, and the Charter is there. So therefore, if there is a claim brought in front of a European judge, this judge must apply the European Charter. There is no way to escape from that. But the possible tensions are multiple in this pact, starting from this sort of wide, if not generalized, detention for people who have not committed any criminal offense. Their fault is simply to be, as we said, irregular. They are not, because they are asylum seekers. They don't have a permission to enter or to stay. This is why they can put in detention. And one of my personal worries looking at the new pact is that the possibility to access justice will be ensured. So if we have procedure at the border, if we have speed procedure, if the guarantees are reduced, at least there should be the possibility to access a judge in order to check whether the process was fair, whether the guarantees have been ensured or not. So my big worry is about access to justice and how this access will be ensured, both for those who are detainees and those, because for detainees we have special rules, because it is a matter of deprivation of liberty, and those who are instead asylum seekers, among them vulnerable people. But here we have an additional problem that I'm not convinced that has been taken into account up to now. It is the fact that in order to ensure full access and full protection, we need an independent judge doing this. Not only a judge, but also a judge who is independent. A judge who is placed in this position according to the rule of law principle. And unfortunately, this is not always true, not because it's my way of thinking, but because the Court of Justice of the European Union has already identified serious problem of violation of rule of law in different member states. So, one point. Second point, this system works if there is mutual trust. There is an independent judge and mutual trust among the member states. But if we look at the European system, which is built on mutual trust, which is the Dublin system, we realize that it is not true, in the sense that there are a lot of cases in which judges from a member states have identified systemic deficiency in the system of reception condition or access to the asylum procedure in another member state. So this is common. Still, we are doing in my country, we don't send back refugees to other European Union countries, more than one. I don't want to mention in order not to create now competition. However, and even, for example, from the Netherlands, they have not sent recently asylum seekers to Italy because of systemic deficiency in the system in Italy. Not for the independence of the judiciary, but for other reasons. So my point is, which is also a political question, how is it possible to build up a new system of asylum, a new pact, without taking into account whether each country who takes part in this pact as an independent judiciary which complies with the rule of law, and whether there is mutual trust among the member states in order to implement the new system, which are, for me, preconditions in order to go further. And apparently, looking at the overall picture, these preconditions currently are not in place. Therefore, I expect that cases will flow in front of us, in front of the judges, and at that point, it won't be easy to manage this situation because of the picture that I've tried to describe shortly. Thank you.
Thank you. Yes, that sort of leads on quite well to the next question that I was going to pose, sort of linking to the concept of access to justice and also what Professor Guild mentioned about, you know, the horrendous occurrences of border violence on the externals of the EU. My sort of next point was going to be about accountability and monitoring mechanisms. So sort of what is there that exists currently and what is there that could be done better? What new suggestions could there be, or does there need to be a sort of complete overhaul in terms of how this is managed?
We can do the other way around now. I don't want to be always the first to speak.
Any comments?
Should I start first? So
yeah.
this issue of access to justice is a central one. So, and it will be more and more important. First of all, we have a problem about access to procedure. And it's again about statistics. If I don't mistake, this is my memory, but I might mistake. In 2022, we had 46, 48 first asylum claim in Hungary and almost 100,000 in Austria, which have a border in common. So is it not a matter of access to procedure? In principle, looking simply at the statistics here, how does it come, this situation? And then we have the point of access to justice. When we implement procedure like those envisaged by the new pact, is very important to think how to conceive the possibility to access a judge. Let me try to explain. So in this new pact, we have, first of all, as I understand it, because the text, I have not been through the text, which has been disseminated only recently. So it's something really new. So, but apparently there is a screening procedure. What does it mean, a screening procedure? It means that someone will determine whether a person, a migrant, is asylum seeker or not. So in order to establish whether a migrant is an asylum seeker or not, it can take a lot of time. Because let's make an example. If we have a person who is trafficked, a woman, this is very common in my country, a woman who is trafficked for sexual exploitation, but she denies the trafficking and the sexual exploitation for a huge number of justifiable reasons. And it only emerges after months or years. And she tells, I left my country because I wanted to have a better life. Is she asylum seeker or not? And if someone, she is at the end, she is because in her story, in her history, there are so many indicators about a person who is trafficked that then they are identifiable, is identifiable as asylum seeker. She says, I'm claiming for asylum because I want a better life. Okay, this is what she says. The person who is making the screening will say, okay, you say that you are asylum seeker, but you are not, because you are saying that you want to have a better life. This is not a ground for asylum in any case. So you are not entering the territory of the member states. Is it a decision or not? Is it possible to access a judge in order to contest the decision or not? This is not clear according to what I've seen in the text, and I fear there is not a remedy in this case. Then we have to see how the access to justice is conceived in this border procedure when the person is detained. Because being detained means not having or having problems in access to a consultant, a cultural mediator, or an interpreter, a lawyer, and the procedure is very fast. So how to ensure appropriate access to justice when there is such a restriction of rights, and also taking into account that normally the procedure in asylum claims lasts much less than in normal claims. So we should imagine proportionality that it is longer, because a person who don't know the language, don't know the culture, don't know the context, don't know a lawyer, and what else, needs time in order to prepare the defense. Longer than a person who stays, financial means, knowledge, and what else. They are already short. They are even more shortened. So how to ensure access to justice in this situation? Last consideration, otherwise I'm very long. There are monitoring procedures envisaged. They are envisaged by the new regulation enacted in 2011 and that instituted the European Union Asylum Agency. The regulation contains a monitoring procedure that can also be effective if proper implemented. So it is envisaged that pool of experts will go on the field, will check whether the effectiveness of justice, for example, is respected. I'm already been involved also in the preparation in the working group preparing possible standard and questions for this monitoring. We have to see how it's going to be developed and implemented. However, a tool exists and can also be a good tool because it can bring to political consequences. So if the expert identifies shortcomings, then they pass the issue to the political context, so to the institutions of the European Union that can also intervene in adopting recommendation and at the end even sanctions. Thank you.
Thank you. Would anybody else like to build on any of that?
I would very much like to agree with my colleague, Mr. Perilli. There is a profound shortcoming and problem in respect of access to justice in the screening regulation, in that, as he has clearly pointed out, the decision, which is an administrative, according to what we understand is in the proposed regulation, is a non-decision, therefore it is not a justiciable decision, that a person is either an asylum seeker or not an asylum seeker, as Mr. Perilli mentioned in respect of his trafficking victim. There will be no access to justice. There is no appeal foreseen. This was raised with the Commission at the time that they produced the first drafts, and it has never been resolved. It is now going to be a terrible burden on judges across the EU, and the Court of Justice will have to come to terms with this, bearing in mind the consequences in terms of refoulement of a screening non-decision. Will judges then have to create from their national constitutional traditions and from the EU's constitutional traditions and fundamental rights obligations an appeal right with non-suspensive effect? I would add that sadly in the procedures, the recast procedures directive, they have got rid of suspensive effect for most of the appeal rights of asylum seekers whose claims are refused. And there will only be suspensive effect in a separate procedure. So even more lawyers have to be involved in order to make separate applications to judges for suspensive effect in order to exercise the appeal right. This is a dreadful thing to be doing, absolutely contrary to what we think of as the rule of law. In the regulation on screening, there is the introduction of this new monitoring mechanism, which was put into the regulation as an alternative to an appeal right. I'm very much in favor of a monitoring mechanism, but I don't think that it can replace the individual right of the person who's subject to immediate expulsion, having been determined as not needing international protection, through a monitoring mechanism that will not provide that person with a remedy. I've been particularly concerned about monitoring in respect of Frontex. We saw that the former director of Frontex, Mr. Leggeri, had to step down on account of the complicity of Frontex in pushbacks and violence in both the Aegean and the Eastern Mediterranean. Of course, he is now standing in the list for the Rassemblement National in the European elections in France. That's about as far right as you can get, which is rather sad in terms of the reputation of Frontex in particular. But we absolutely need to have better and more comprehensive monitoring and external monitoring of Frontex. We have replaced also the fundamental rights officer, but that is an internal position within Frontex, dependent on the director, and does not constitute an independent monitoring mechanism. We cannot continue to have deaths in the Mediterranean because the calls of who is in distress are made by the director of Frontex, who decides this is a criminal justice matter rather than a search and rescue matter under international law, SOLAS and UNCLOS.
Thank you very much, Professor Guild. Ms. Romeo, did you have anything to add on to that matter?
I would have a lot to add. I'll speak forever. Yes, I mean, I do very much agree with my co-speakers, of course. And but maybe before adding on that, because I think maybe it's not clear for everyone what the new Pact of Migration and Asylum entails. So just wanted to say a few words. That one of the main introduction of the pact is mandatory border procedures for certain categories of asylum seekers. So now border procedure already exists, but they are not mandatory. So they have been used massively in the context of the implementation of the EU-Turkey statement. So all asylum seekers coming from Turkey to Greece had to stay in the Eastern Aegean Islands until they had a decision. Well, there were some exceptions, but that would be a bit long. They have been implemented a bit in other member states, but they are not compulsory. Now, when asylum seekers come to the EU, well, they are more or less free to stay in the territory of the country where they arrive. They are not detained, they're not deprived of liberty in most of cases, or maybe they are, but for, let's say, a very short time, just in order to their information and fingerprints to be taken, but then they are free. They are not detained at border. With the new Pact of Migration and Asylum, actually, certain categories of asylum seekers coming from countries with a low asylum recognition rate, so third countries that do not produce many refugees, would need to stay at borders. Then, okay, the formula would be a bit adjusted, but okay. What does it mean? That something that now already happens, and we see that it's very problematic, will happen on a large scale, on a very large scale. And we can already see when it was implemented on a small scale that it created a lot of problems. And one of the problems was the access to remedies, was the access to justice. I found very fascinating that there is even a report that was commissioned by and adopted by the European Parliament that says, I love this sentence, something like, it's in the intrinsic nature of border procedures that human rights and procedural guarantees are not respected. There's nothing that can be done to change the fact. That's the fact. More the border procedure corresponds to more risk of human rights violation and more risk of not guaranteeing also the procedural safeguards. And that's what we're going to have in the next years. And that's, of course, a big problem in terms of access to human rights and to justice. But there's another problem, which is that what's the goal of this border procedure? What do we want to achieve? What's the consequence that we want to achieve? Is it that we want to process people quicker and to send back to their countries of origin, or to save third countries people? Okay, let's say that this is the aim. I might personally not agree with that, but let's say, okay, this is what border procedure are for. But is it what border procedure will actually bring? I think not. And that's the point, because we might say that we want to process very fast people at borders and then send back those who don't have the right to stay. But how do we do that? I think that just before COVID, the return rate, which means the let's say, the ratio between the people that receive an order to leave and the people that actually leave voluntarily or forcibly. Before COVID, it was around 35%, I think, and now it has dropped under 20%. So even now, when we want to send people back, we can't. And that's everywhere in the EU. We just can't bring people back, and that's a problem that's not addressed by the pact, because all the structure of the pact lies on that we can actually process fast people and bring them back. But how? And what do we do when we have decided that someone has to leave and this person has an order to leave? But we can't. We can't because maybe the third country where the person should be returned doesn't want to cooperate. Maybe because luckily there are still some human rights guarantees that mean that sometimes deportation can be stopped, that we cannot just bring people and take them back very swiftly all the time. So that's a problem that is not solved. Or as well, the idea of border procedure is that asylum claims can be processed super fast. But in reality, it takes time. It takes a lot of time to process asylum claims. So how do we process super fast asylum application? Where does the money come from? Are all member states going to hire thousands and thousands of case workers working on cases? I don't think so. It's difficult. Where do we put the people? Some years ago in 2020, when the Commission issued the first draft of the new Pact on Migration and Asylum, I was working in an NGO at the time, and with some colleagues, we tried to make some simulation of the implementation, especially wondering how many people would be detained if the new border procedure was already in force, and whether it would actually be possible to detain all the people that would have been detained. Now, okay, the formula has changed a bit, so I cannot tell you what it would be like now. But what we discovered by applying the rules of the first draft to the past years is that it's just impossible. I think the figure that we found for Italy is that for every, let's say, detention place in a detention, in migrant detention facility, there would have been like 7-8 people for one available place. So where do we put these people? Should we just like build a lot of new detention facilities to use in moments of crisis? And then when there are less asylum seekers, what do we do? It's really complex, and no one really thought about this question while drafting the pact. We don't really know how to do it. It's just super difficult. It puts a very high burden on border countries, on frontline countries, and we saw that very well when implementation of the EU-Turkey joint statement. At some point, I was in Lesbos recently in autumn to carry out my fieldwork for my research, and at some point on a very small island, they had something like 22,000 asylum seekers waiting for their process to be claimed. And they were 15 case workers of the Greek Asylum Service, plus maybe 10 at the time EASO case workers. And when I asked her, what was your main challenge at the time? They were like, yeah, we just wanted to stay alive. Because we were just like 25 people dealing with 22,000 asylum seekers. How do we do that? There's no way that this can actually happen in a swift and orderly manner. There's just no way because there is no structure, because it's just impossible. It's not a solution. And that's why what I was talking about informal practices, because then they had to find ways to deal with that, to deal with the fact that things were not going as the EU thought they would go. We were talking before about like the judges try to provide some remedies for the human rights violation. But what I find very disturbing is that for having a remedy, it takes so much time. So very recently in Italy, we had an issuing by the Cassation Court, so the highest court in Italy, saying that it's not legal to send to give asylum seekers to the hands of the Libyan Coast Guards. We have been doing that for years and years and years and years. And the issuing of the court is arriving now in 2024, and we have been doing that for almost 10 years. So the process is very long. There's a lot of like human rights violation going on. Of course, there are some remedies, but they take a huge effort from civil society. I think that was one of the points that you raised when you sent us the question prior to the webinar. Civil society does a huge effort in bringing cases to courts. it's just like a huge effort when you have a very strong political pressure for this kind of policy to be implemented. Of course, there is a resistance coming from the other part, something that can block this human rights violation that happen in consequence of the implementation. But it's very unbalanced because the pressure to implement this policy is huge, and what you can do to actually create a remedy, it's very small in comparison to all that happens. Even Frontex has a mechanism a complaint mechanism, but good luck if you're an asylum seeker who has been pushed back and I don't know where to understand how you can file the complaint to Frontex. Yeah, of course, few people managed, they were funded by lawyers from NGOs who helped you to do that, but it's in terms of numbers is nothing compared to all the human rights violations that happen as a consequence of the implementation of these policies.
Thank you very much. That was a really insightful section, especially about the sort of rights of migrants. I think it's returning to the sort of access to justice point. It's a really key issue going forward. Slightly more broader sort of abstract question. Do any of you think that the EU's handling and the current situation with migration, do you think that damages its sort of self-image as being fair and liberal and modern? Going back to the sort of topics we've discussed of border violence and the horrendous things happening on the peripheries, does it affect this sort of self-image that it projects outwards of being fair and modern and just and liberal? Would anybody like to kick us off with that one?
You're going to have to tell us when to speak, Alicia. We're not going to...
sorry. Dr. Guild, do you have any points on that?
Okay. Yes. I think that what we're looking at the moment is a very schizophrenic set of policies in the EU. On the one hand, the arrival of and the extraordinarily rapid integration into rights of over 5 million Ukrainians, very little concern, very little public outcry in respect of the arrival of the Ukrainians and others who were resident in Ukraine, but who arrived after the full Russian invasion. There has been an extension to the very end of the 3 years, and now everyone has put their thinking caps on about what to do about them thereafter. So we have an example of a very positive, very rapid EU reaction to an immediate problem of an outflow of large numbers of persons from a neighboring country. Then we have the pact completely disassociated from the temporary protection scheme for Ukraine, where there seems to be no end of sneaky little bits added into the legislation to make access to justice and access to the territory more difficult. Now, what I would say in reply to Gaia is that I am a professor of law, and I do believe in the power of the rule of law. And I think that the EU, to a fair extent, also believes in the necessity of the rule of law, because without the rule of law, the EU cannot operate. I think this goes back to our question of mutual trust. The EU is built around law, and it depends on protecting the rule of law. Therefore, when the Court of Justice finds that there have been practices in the area of asylum which are contrary to the Charter, I'm not as negative as you are about whether or not implementation follows. Do member states begin to bring their practices into line with the judgments of the Court of Justice? And I think we have the Commission versus Hungary case on the Hungarian-Serbian border as an example of very difficult implementation, But nonetheless, even in a very Eurosceptic regime in a member state, tremendous attempts to at least give the appearance of complying with the Court of Justice's judgments. And of course, that was the first time that Frontex withdrew from a joint operation. So I do think that if I cease to believe that the rule of law applies in the EU, I'll probably have to cease being a professor of law and become a professor of politics.
Thank you very much, Professor Guild. Yes, that's certainly that would be quite a change. Mr. Perilli, do you have any comments on this?
Okay, I don't know about the self-image, but I would say something about the real images that we see in our job, and that make it very, very difficult. In the sense that what we consider our job is to be fair and reasonable, as long as we can do it in that way. But in the field of migration, sometimes we have really to think of what we are doing. Let me make an example. No? You have spoken about, the Professor Guild said about the number of expulsion, no? The returns. If I don't remember, if I remember well, she said 90,000 per year. That might be this the figure. For Italy is in between 3,000 and 4,000. But the number of detainees per year is twice. That means what? That 4,000 people have been detained and not repatriated. Since detention is only aimed at repatriation, because these people have not committed any criminal offense. According to the European Union law, detention is always, apologize me for using this Latin word, an extrema ratio, the last resort measure, always, if there are not further measures that can guarantee the same result. And it is aimed at expulsion, repatriation, but half of them are not repatriated. Why these people were detained then? Why they were detained? And which is the image that we have? The image is when we, because the judge, according to the Constitution and also of the Charter of Fundamental Rights, has to validate the detention. In Italy, it is within 48 hours. So this person is kept, is detained, is an asylum seeker, and is brought in front of a judge. And the judge has to apply the legislation. Therefore, if the legislation is respected, the detention has to be validated. So, and it is not rare that this person who appears in front of the judge, I normally say, would you like to ask something to the judge? And the question is not rather often the following: why I am detained? And he said, you are detained because you are an asylum seeker, and until your procedure will be decided, you have to be in detention, because if your claim is going to be rejected, you will be returned to your country. But I cannot say that 1 out of 2 will not be returned. I cannot give this explanation to them, that it might be possible that you are returned to your country, because you, if I have 2 cases in one day, probably 1 of the 2 is not going to be returned. So we have this situation, and we're speaking about deprivation of liberty, which is, according to the rank of the fundamental values, one of the most important. However, this is not, I mean, this does not prevented, apparently, in our European legislature, it is not yet completed, but it seems that it's going to the end, to even increase detention, because now the risk is to have very broad detention associated to the border procedure. If I don't mistake, this is what I understood, that even possible to detain minors with family who are above 12 years old. This is what I've seen. I'm not sure because the text, as I said, I've not been through, but apparently this is what. And therefore, when you speak about self-image, we should ask ourselves, why are we are doing this? Why we are doing this? So we know the reality, we know the situation, we know the facts, we know the statistics, and then why are we doing this? Thank you.
Thank you. Yeah, no, I think it's definitely really important to question ourselves when we're considering sort of concepts of liberty and self-image, because it's sort of, it differs. Everyone's perception is completely different. Ms. Romeo, do you have any final remarks on that one? And then we will move on to some questions from our audience.
I'll be very brief this time. Yeah, maybe I can build up on Judge Perilli's last sentence. Why are we doing this? I think that we are doing this because somehow the extreme right has managed to set the agenda on what are we talking about when they discuss EU and migration asylum policy. As also Professor Gill was saying at the beginning, if we look at the numbers, like why are third country nationals in the EU, which kind of residency permits do they have, we will find out that most of them are here because they have an employment permit, because they have like a student's permit, because of family reunification, and not many of them are here because they arrived as irregular migrants or because they applied for asylum. Like most of people just arrive in Europe for other reasons. But for some reasons, the extreme right managed to shift the public debate about migration on irregularity, on refugees, and all the other parties followed, and they managed to set the discussion on that. And this is why we are now discussing this, and we are not discussing about labor migration, for example, that in terms of numbers is actually much more important for us, and it's something that we should be discussing much more. But in when we discuss asylum, also because I'm a political scientist, so of course for me, like understanding the politics is key. We are doing this because for you policymakers, this was a response to a need, because I think that for EU policymakers, the fact of adopting the new path was, in their view, a way to say, okay, because we are bringing you a solution, a moderate solution, because that's what happened, that now something that for human rights defender can be easily portrayed as a very, let's say, a very restrictive, very extreme policy as against asylum has been portrayed as something very swift, very rational, very fair, very efficient, but it's really not. But still, in asylum policy, I feel that, let's say, the political value of message in most of the cases counts more than the goal of the policy itself.
Thank you, Ms. Romeo, for finishing us off on that one, and thank you to all of our speakers for some really rich discussion there. So we have a few questions from our lovely audience. The first question, I think, is primarily aimed at Professor Guild, returning to the concept of the Frontex agency. So the question reads, Frontex agency is facing multiple criticisms. We can think of pushback practices in the Mediterranean, or the presence of its previous director on the list of the French far right for the European election. Do you think this agency needs to be reformed, and how?
Well, I certainly think that the reforms that Frontex has gone through recently with the 2019 regulation and reform have not been sufficient to put fundamental rights at the heart of the agency. And I think that we see from the current director's most recent appearance before the European Parliament that he's having a very hard time thinking about fundamental rights as being a core component of the mandate of his agency. That needs to change. And the only way to change that is there needs to be a change in the ethos of the institution, border guards. When I did some research on this a couple of years ago, I spoke to a retired senior border guard from one of the very big member states who said to me, well, if you don't want unlawful practices in your border guards, you have to have a policy from the top to the bottom that it is unacceptable and you will lose your job if you participate in unlawful activities. And therefore, pushbacks are unlawful activities. We need to make a bit of progress there. There are now 2 cases lined up before the full court from the General Court for the Court of Justice of the European Union in direct actions by individuals challenging pushbacks carried out by Frontex from Greek islands, primarily Lesbos and Leros. And the General Court was unable to, has held that there is no liability in respect of Frontex, notwithstanding the fact that in respect of the applicants, the Greek officials had not even issued an expulsion decision when the people were put on Frontex flight and flown back to Turkey. We'll see what the Court of Justice itself says, whether it's going to try and put a little bit more law into what's happening in respect of Frontex at the moment. There will definitely need to be an external push to bring more rule of law and fundamental rights into the practices of Frontex. I don't think it's going to come from the inside. There's no indication that the departure of Legeri has brought about that kind of an enormous change, nor that the newish, more than 2 years old now, fundamental rights officer is capable of doing this.
Thank you. Thank you very much, Professor Guild. Would anybody else have any comments on that question? Maybe Ms. Romeo?
I don't have anything to add more to what Professor Guild said. I think she's the most qualified here to, I mean, just Perilli maybe as well. But yes, actually, I would like to answer maybe to the second question because I feel that's something more in my field of expertise about the agreements with Tunisia and Turkey.
Okay, well, we'll come back to that one in a moment. Mr. Perilli, did you have anything to add on the matter of the first question?
Oh, thank you. I also expecting to reply to the second, also in legal terms. Okay, thank you.
Okay. Well, we can move on to the second one then in that case. So I'll read it out for everybody. The EU has signed an agreement with Tunisia and Turkey to prevent migrants from crossing its border. Are these agreements efficient, and should the EU sign more agreements like these? Who would like to start us off with that one? You're both keen, so you can fight amongst yourselves.
Miss Gaia, you start first, then I will.
Okay, I will.
Okay.
Okay, so in political science, there is a big debate about what effectiveness of migration policies is, because of course it depends. What is your goal? There might be different goals. So how can I say if these agreements are effective? Are they effective for the purpose of delivering an answer to, let's say, the public opinion? Maybe yes, at least we can probably say so. Are they effective to putting Meloni back on the, let's say, on the European stage of those that can lead EU migration policy? Yes, for sure. I will not talk again about the human rights, let's say, doubtful aspects of these agreements, because I feel we have been discussing that a lot. But I think that there is one very interesting aspect of these kind of agreements, which is that they are informal agreements in reality. Both the EU-Turkey agreement of 2016 and the Memorandum of Understanding with Tunisia, they are a sort of, let's say, declaration of intents from the two parts, but there's not a binding contracts, which means that we don't really know what these agreements means, and they can be interpreted differently. Like during time, the EU might say, yes, this is what we meant. The counterpart can say, this is what we meant. Then there's a lot of money which is given to the third country to implement say the policy that we want them to implement, namely take back or stop in the case of Turkey, and let's say prevent migrants from arriving to the EU to the EU territorial sea in the case of Tunisia. But what actually is in the agreement and what is not, nobody really knows, and everyone can have its own interpretation on what it means. And that creates actually a problem of democratic scrutiny, because a lot of EU money is given to third country for some aim. But then how can we really monitor how this money is spent? How can we really monitor, even if we would, let's say, if I would personally agree with the aim of these agreements, how can I know if the money is really helpful in getting to the goal that we want to achieve? how can we monitor this agreement? How can we know how many asylum seekers Turkey or Tunisia prevented from come to the EU? We actually cannot, because there's not like a proper monitoring mechanism, because it's not clear which funding is exactly part of the agreement, which funding is not, how is it spent, how can we evaluate whether this money actually contributes to the aim that the agreement was made. We don't really know. Also because this in migration policy is a field that when we talk about externalization, it intersects with foreign policy of the EU, and foreign policy is one of the few fields of EU policy where the council still has the last word. It means that the parliament cannot really exercise its democratic scrutiny on what's decided. And this is something that it's definitely, it definitely goes, let's say, against our values. It's definitely not good for, let's say, for our democratic countries, for our democratic institution. It's something which is decided at the council level, and then it's implemented, but there's no way to understand exactly what it means and how the money is spent and why, and if it's effective, if it's not expensive. We just do not know. And this is something that is very disturbing.
Thank you very much, Ms. Romeo. And Mr. Perilli?
Thank you. Thank you very much. I will not speak about the agreement and the legal value. It might be Professor Guild can say something. As I know, the agreement with Turkey is not signed by the EU, but signed by the member state plus the EU, because there is no legal ground in the treaty for that agreement, and that is funded. The memorandum with Tunisia is not real in the sense that it is a memorandum. An amount of money was sent at the beginning in order to, let's say, give a solidity to this memorandum. But then on October 2023, the president of Tunisia sent the money back, 60 million to Europe. He did not want this money, and I think he's dead after this. So I don't think it's something that is implemented. And also consider that most people coming from North Africa to Italy nowadays, they come from Tunisia and not from Libya as in the past. And this is also why this attempt was made. And of course, there are people not from Tunisia. There are many from Tunisia, many, some thousands, almost, I think in 2023, they were about 18,000 Tunisian, but for the rest, they were 150,000 last year in Italy. They come from sub-Saharan countries, so they have crossed the desert and the Mediterranean. But speaking about effectiveness, so the students say efficiency, but I prefer effectiveness as well, as Ms. Gaia said, because effectiveness has a precise legal meaning in the context of European Union law. We find it in the Treaty on European Union, effective judicial protection, and we find it in the Article 47 of the Charter of Fundamental Rights, effective remedy. What does it mean, effective? It means that we have to protect the rights of the people fully. Whatever mean we use, it doesn't matter. We have also procedural autonomy in the member state. We can use whatever we want, but it has to be effective. If it is not effective, we have to change our internal rules to be effective and to protect the rights of the people. So these people are asylum seekers. So we have to consider the rights to see whether they are grounded or not. And in case they are grounded, we have to protect them. That's it. If we make an agreement with Tunisia or with Turkey, we have then to be sure that the rights of the people will be effectively protected in Turkey or in Tunisia. This has to be the precondition. I don't see other different possibility but that. Turkey, I mean, I'm a bit biased on this. I was independent expert for the EU for many years for the negotiation for the accession of Turkey. I stopped in 2015 because the situation because not tolerable and even a bit risky for the expert at that point. And after that, they've arrested almost 4,000 judges. Some are refugees in our member states. I was also a report in an international trial in Geneva organized by the civil society about rule of law, fundamental rights. So my conclusion is in the report. There is no rule of law. There is fundamental rights are not respected in Turkey. So which is the effectiveness of this agreement then? This is the question that I send back. My conclusions are there, are in the report, can be found in internet. So I simply refer to them. Tunisia, again, is not by me, but Tunisia is included in Italy in the list of safe country of origin. We have a very long list since March 2023, which includes also Côte d'Ivoire. If I remember well, Côte d'Ivoire, the percentage of protection is above 20% in Europe. So it would not even included in the border procedure according to the new pact. One court in Italy, the Court of Florence, the Migration Court of Florence, has declared Tunisia as country which is not safe and has disapplied the inclusion of Tunisia in the list. Why? Because there is no rule of law and because there is not an effective remedy to protect the rights of migrants. So the answer to the question is, how can we build up efficient agreement with countries who are not effective in the protection of fundamental rights because there is not rule of law? This is my question replying to the question. Thank you.
Thank you very much, Mr. Perilli. Professor Guild, did you have any swift comments on that question? Because I'm really keen to tackle the last question that we have in our Q&A as well, to have time to move on to that as well.
No, go ahead to your last question.
Okay, lovely. Well, we obviously have a mind reader in our audience, as this question was essentially very similar to what our closing question was going to be for our session. So I'll read the question out. With Hungary, Italy, Sweden, Finland, and soon the Netherlands having either a far-right party in power or inside a government coalition, do you observe or expect an even further push against migrants, or do you think that they will face the wall of reality, as some journalists said about Meloni and her plan to blockade migrants? Would you like to start us off with that one, Professor Guild?
Sure. I think that we get a lot of noise every time a far-right government is formed in Europe, and much less noise when we don't, when we get a center-left government in place. And while everybody was quite happy about the most recent elections in Poland, we seem to have completely forgotten about a large member state that was particularly problematic on rule of law, which has moved in another direction with much greater respect for rule of law. So I think this fascination with the far right is perhaps, of course, it's important, but we must not exacerbate or exaggerate what it is. I think that our question is always in this field, who do we want and who don't we want? So as I started off saying, we have over 300 million entries across the external borders of the EU every year. And the very, very, very large vast majority of these people are extremely welcome. So people coming to the EU and staying in the EU are very welcome. We issue over 300 million 3 million first residence permits to third country nationals every year, most of them for work purposes. Don't tell me that we don't like third country nationals. This is not right. If we say third country nationals come to the EU because they are driven out of their country of origin, that's certainly the case for some, but the fifth largest country of origin of people getting those first residence permits in the EU are US citizens. Now, are they being pushed out by Mr. Trump or not? What is migration in the EU? Who do we want? Who don't we want? And do we know who we want and who we don't want? And is somebody who we didn't want yesterday somebody we do want today? Therefore, I think this question is an extremely difficult one to answer. And I would be very reluctant to enter into some of the more Baroque answers about it.
Thank you very much, Professor Guild. Ms. Romeo, would you have any comments on that?
Yeah, I think, what can I say? That, yeah, as I already mentioned, sometimes I feel on one side, there's always one political value of the official policy of what like national governments, like EU institutions say about what is the policy that they want to implement, what they say in the public debate. But then sometimes they do something else, let's say behind the door, because they know that they have some practical problems that they have to face. And so sometimes even if they defend a very restrictive policy, at some point, of course, they have the wall of reality. They have some practical issues. They have to solve it. And they understand that for solving this issue, they cannot really implement a very restrictive policy that they have been defending. So then they do something else. So what I expect in the future is that, yes, probably far-right parties will keep defending very restrictive policy in relation to migrants and refugees. But then I would not be surprised if they would adopt other solutions, let's say a bit, not making them too public, but to really face the real problem that are in the fields, meaning that, I mean, we might need to face the fact that we cannot return people. We might need the fact that we have a very aging population, and we actually need like young people to come and work and pay for our pensions. So all this, and I think like, even extreme right governments, sometimes they can understand that. So yeah, this is a bit what I expect, that they will keep pushing for very restrictive policies, but then they will also have to deal with reality. That might mean implement less restrictive policies.
Perfect. Thank you very much, Ms. Romeo. Mr. Perilli, I know you don't would refrain from discussing political matters. Did you have any final comments on that, or skip that?
I refrain. Thank you.
Lovely. Okay. Well, I will close us off by thanking you all for having taken the time to come and speak to us and share your knowledge and your perspectives and your insights on these matters. And it's definitely food for thought. I think most of us here in the audience are students, so it's definitely, you know, further avenues of study for us, things to be looking at in the future. So thank you you three for coming and speaking to us, and thank you for our audience for having joined us today and provided us with questions. And I think that's just about everything from me. Thank you very much to everyone.
Thank you for inviting me. It's been a pleasure.
Oh, awesome. Well, it's been delightful having you all, and I'm really glad that you could make it.
Yes, for me as well. Thank you very much for you all for organizing the workshop, and for my two speakers for the very interesting discussion that we had.
Thank you. Thank you very much also from my side.
Thank you.